Lords. There are many things I don't know about social security law, but I think in at least 4 respects there might have been at least something of a transformation over the short adjournment. Can I see if I can give you some answers to some of the questions, the miscellaneous questions that were asked about the way in which the statutory scheme operates? Revision or supersession, is there a mechanism by which to decide which option to follow? Which I think was a question that Lord Roger asked. So far as that is concerned, I think the answer that I gave was the correct one, however unsatisfactory that may be, which is that the regulations set out the bases upon which each of those individual powers can be exercised. You saw Regulation 3 in the 1999 regulations dealing with revision. There are equivalent bases provided for in relation to supersession in a regulation which is not in the bundle, which is Regulation 6 of the 1999 regulations. And that deals, for example, with and provides a basis for supersession when there's been a material change of circumstance. There aren't any specific provisions dealing with the choice between the two. So to the extent that there is an indication in the legislative scheme, and it's probably quite a powerful indication, it is derived from the bases upon which those separate powers can be exercised.
That's Regulation 6 of the 1999.
Exactly so. And that deals with supersession. We can easily provide you with a copy of that if necessary, but it stands in contrast to the bases which exist for revision.
Could you add it to the other ones you were going to give us? Thank you.
Secondly, can you revise a decision to revise? The answer to that is yes. The oddity of it is that the statutory scheme and indeed the regulations themselves only refer, I think, in the context of revision, to revising a Section 8 decision or a Section 10 decision, which is a supersession decision. That doesn't preclude a revision of a revision, and that does frequently or relatively frequently occur. I think the principal basis on which Section 9, which is the one dealing with that, is not referred to, dealing with revision is not referred to, is because the theory is that if you are revising, you're by and large revising the original decision again, if that makes sense. So you're doing it that way. But you can and they do revise revisions. So far as Section 72 is concerned, that's Section 72 of the 1992 Act as enacted. If you'll recall, the up-to-date or the current version of Section 71 is behind tab 25. That only contains Section 71. In the next tab, there is the as enacted 1992 Act. It also includes a section 72, dealing, I think, with income support in a particular way. The short point in relation to that is that it is, we submit, unlikely to materially advance or assist in the resolution of these issues because it, in effect, provides what is substantially the same sort of power, but does so by reference to the different regime under which, different mechanisms under which awards of income support of that kind were made. So, for example, they required a direction by the Secretary of State. So the section is set up to deal with that different original decision-making process, if that makes sense. Yeah. The equivalent provision now is not headed income support, I'm told it's headed job seekers allowance, but it deals with essentially the same thing, and there is a Section 71 capital A, which is the equivalent of old Section 72. But as I say, I don't think there's anything that is really materially going to assist you there once you recognise that the essential tests are the same. So far as process is concerned, is the first thing that the person hears that the matter has been revised. Answer, yes, that can happen. As I understand it, the department frequently carries out reviews of particular individual cases and groups of cases. And as part of that reviewing mechanism, there may well be, sometimes is, engagement with the customer. That isn't, however, invariably the position. There are some circumstances in which a revision occurs and the first thing that the person knows is that the award has in fact been revised. But of course, in that situation, as I'm sure you will appreciate, that the person concerned would then have the various statutory rights of appeal that are provided for in the legislative scheme. My Lords, we've undertaken to provide, we haven't been able to do it over the short adjournment, but we will do, we'll provide you with the historic legislative provisions so far as relevant, and we'll add to that list Regulation 6, if that's possible. My Lords, I dealt with at least one answer to the historic line of argument my learned friend is running on the assumption that the premise, the first of the stages of the argument, was correct, namely that there wasn't a common law right of restitution available way back when. We at least have put a question mark over that. This is not the case, I suspect, in which the court is going to be even remotely attracted by seeking to conduct what might be a relatively complex historical analysis as to the stage at which the law of restitution had reached by various historic points over a spectrum. But my Lords will also need no reminding that the restitutionary remedy is and has always been a relatively broad doctrine, and we respectfully submit that it is at the very least doubtful that the position was that in 1986 or at any point thereafter one could say with the requisite degree of clarity there is no restitutionary remedy, or more accurately that Parliament can be taken to have believed or known that there would be no restitutionary remedy. And in my submission, we've set out in our case some possible bases on which that argument might have been deployed.
And is this your paragraph 33?
It is.
Yes, I see.
It is. But as I say, that what we're not inviting my Lords to do is to start deciding on whether or not there was or there wasn't. For my purpose, it is sufficient that there isn't clarity on that issue, and that therefore that Parliament cannot be assumed to have been legislating in the knowledge that there was, or indeed that there wasn't, a restitutionary remedy at that particular point in time, or at any particular point in time. I've dealt with the pre-existing regime and what we say about what I keep calling the 119 point, at the point that there was a period of time when Parliament can be taken to have assumed, if that premise is right, in other words, if there isn't a common law power of recovery, that they were content to leave it that way. As I say, another answer to that is you can't make that assumption, because the law on restitutionary remedies was at all material times at the very least doubtful. But I've made my submissions even assuming that is wrong, and that you conclude that the position was that you couldn't have a common law right at that stage. And I won't go back over that. My Lords, the final point on which I wish to deal in opening was the question about analogy with the tax cases, whether they were truly analogous. I've made the first submission that I wish to make in relation to that, which is, as it were, a cautionary note against underplaying that point on the basis of the title in our case, which is headed Analogy with the Tax Cases. The submission I made earlier was that actually those tax cases are no more than a confirmation and application, an example of an application of a broader principle, which we respectfully submit is of critical importance to the resolution of the issues that arise in this case, which is what is the correct approach in principle, whatever degree of nervousness one feels about Parliament's intention at various points in time, what is the correct approach in principle for this court to adopt in deciding whether or not Section 71 excludes the common law right or remedy? And my submission, which I won't go back over, as you'll appreciate, is that the test is a strict one. It is that there must be, in order to exclude, express words or necessary implication, and by necessary implication is meant direct inconsistency. It isn't enough to simply say, well, surely Parliament might have intended this, that or the other. There is a strict mechanism, strict set of principles for testing whether that was or was not the parliamentary intention, and a degree of clarity is required. The Court of Appeal, in the judgment of Lord Justice Lloyd, who dealt with this particular point, produced a set of reasons for distinguishing, or really one reason for distinguishing the tax cases. He saw in his judgment the force of the potential analogy with the tax cases, but then concluded that they weren't truly analogous because in this case we're dealing with overpayments by the state, not overpayments to the state. In my respectful submission, that isn't a proper or fair basis for distinguishing those cases, still less for undermining the very important point of principle which they repeat and apply. It was not the basis for the decision in any of those tax cases that the payment went any particular way to or from the state. That is not, in our respectful submission, a principled distinction in any event. The state, in other words, for this purpose, the taxpayer, may be a more or less deserving claimant, but the distinction in my submission can't turn on assumptions one way or the other about whether or not the state is or is not, in a particular context, a deserving claimant.
They cite Lord Gough, of course, and the Bill of Rights and all that. But I mean, there is also the competing idea, I think, as you say, that the Parliament votes money, and money under the Auckland Harbour principle is meant to be spent on proper things which are authorised by statute. And you could say, you could turn it around and say, well, equally, you should be able to get back things which are not.
Well, I do, but my position almost prior to that is to counsel caution about seeking to found a distinction on the well-deserved nature or otherwise of the particular individual claimant in the individual case. As I say, it's evident from that line of cases that the principle that was being applied, the rigour with which the principle has to operate if you're excluding a common law right or remedy, simply did not turn in any of those cases, repeatedly going up to the House of Lords, on the nature or identity or particular characteristics of the claimant. The principle is based on something far more fundamental, which is the court's role as guardians of the common law rights and remedies that exist. And it is in recognition of that that the principle has been expressed as firmly as it has. Parliament can, of course, take it away, but if it's going to do so, it must do so clearly. Otherwise, those are my submissions in opening, unless I can assist further at this stage.
Yes, thank you very much. Yes, Mr. Trouble.
Sorry, Mr. Trouble. Do you want both? No, just one of them. Well, your Lords will appreciate this. CPAG's case is that the adjudication provisions now to be found in the 1992 Act, read together with the 1998 Act, form part of a carefully constructed statutory code. The recovery provision to be found in section 71 forms part of that code. And I repeat at the very beginning of these submissions, the submission made to the Court of Appeal and accepted by the Court of Appeal, that the threshold to section 71 is to be found in section 71(5)(a), a provision which we stress has been present in essentially the same form throughout the relevant legislative history. Importantly, it follows that all decisions to alter an award, which up to the moment of its alteration is final, fall within the scope of operation of section 71. Operation of a final award will now be because of the statutory provisions relating to revision or supersession or repeal. And the grounds for supersession or alteration may be because of that the award ought to be varied because of some mistake or fact or law, change of circumstance or official error. But if we say, but only if, the mistake arose because of a misrepresentation or a failure to disclose, the sum can be recovered under section 71(1). That submission is essentially to the effect that section 71 covers the whole ground of possible mistakes or errors. And in our submission, my learned friends' submissions for the Secretary of State have two main planks. First of all, a submission that section 71 does not cover the whole ground. He says, effectively, that section 71 is only in play where there has been a misrepresentation or failure to disclose a material fact. I'll come back to that in just a moment to foreshadow our approach to it. And the second submission is that there's nothing in Section 71 or the statutory code as a whole which either expressly or by necessary implication excludes a common law remedy. So in a nutshell, our response to those two provisions very quickly is that Section 71 does cover the whole ground. If one bears in mind, as it were, Section 71(5), every possible mistake or error will lead to a revision, supersession, reversal on appeal.
So we're looking at section 71(5)(a), are we, or?
Well, either doesn't matter. I'm dealing with 5A because I'm moving on to because I've expressed the submission in terms of revision or supersession. So if we go to section 71(5)(a),
Tab 25,
tab 25, yeah. Every error, if I can use that word in an award, which leads to a change to that award, will be the subject of a reversal or variation on appeal, or the subject of a revision or supersession under either sections 9 or 10. So if one is looking at section 71(5)(a), it does cover the whole ground of any error, to use as neutral a word as I can, within an award. In our submission, as I submitted to the Court of Appeal, the argument about section 71 is bedevilled by the order in which the subsections are arranged. If this section had been if the section had started with a formulation such as something on the following lines: whenever an award is reversed or varied on appeal, or is revised or superseded, the Secretary of State may recover benefit if the condition in subsection 2 is met. And subsection 2 then said the condition is that the Secretary of State has incurred expenditure because of mistake or caused by error, caused by a failure to disclose or a misrepresentation. Then one could see easily that the whole territory of the revision provisions was being covered by section 71. The accident that the threshold provision is in section 71(5)(a) is precisely that. It is an accident arising from the legislative history and ought to have no consequences for the availability or otherwise of a restitutionary remedy, particularly as the forerunner of section 71 was drafted at a time when no one thought there was a restitutionary remedy. It's almost like saying, in the case of Munro, indeed we'll see this is precisely what the taxpayer did attempt to do in Munro, that the scope of, I think it was section 33 of the Taxes Management Act, is to deal with situations where there has been a well-established practice of payment of tax in these circumstances. The Court of Appeal was anxious to stress in Munro that that was a basic mistake. The scope of section 33 was whenever there had been an assessment to tax. The revenue had a defence to repayment to all provisions falling within section 33 if the payment had been made in pursuance of a well-settled practice. And that distinction between the remedy, which in this case arises where there has been a failure to disclose or a misrepresentation, and the scope of the section is an important distinction. And Malone and Friend's characterisation of section 71 as only being in play when there has been a misrepresentation or failure to disclose misses, in our respectful submission, the fundamental structure of the provision. I'll come back to that and see it in the scheme. The second fundamental building block of Malone and Friend's submission is that section 71 does not expressly exclude any common law power of recovery. Well, we submit that that is unsurprising, given the fact that no one would have thought there was a common law power of recovery in many circumstances until very late on in the legislative history. And the Secretary of State accepted in the Court of Appeal that there was no common law power of recovery on his own case until 1998, when the adjudication provisions merged decision-making with the individual, the Secretary of State, who had the duty to pay. So one wouldn't expect to find within Section 71 anything that either expressly or by necessary implication excludes a power, a common law power of recovery, at least deliberately inserted by the draftsman, because the draftsman would never have thought there was such a power. You have to remember that Section 71 forms
You're
part...
muttering a little bit, Mr. Drabble. If you would speak up, it would be easier.
I'm sorry. I'm sorry if there's a problem about it. Let me turn that one on too. Sorry, the point I was making was that an important part of my learned friend's case is that Section 71 doesn't expressly include any common law power of recovery and doesn't by necessary implication. My rejoinder to that is that it is plain that the forerunners of Section 71 were drafted at a time when no one would have thought there was a common law power of recovery in these circumstances, and where the Secretary of State accepted in the Court of Appeal that there was no common law power of recovery until 1998, when the two provisions, the two lines of decision-making in the adjudication sense, and the power to pay merged in the one individual, the Secretary of State. Accordingly, it is in our submission a fundamental mistake to be looking to the language of Section 71 for something that indicates an express, in particular an express exclusion of a common law power, or even one by necessary implication arising from the language. We do see that the statutory scheme as a whole necessarily excludes any parallel common law power.
And that's your real point, isn't it, Mr. Drabble? I mean, there isn't. I mean, on your analysis just now, it isn't excluded either expressly or by necessary implication, looking at the language. But you say, as I understand it, if one looks at the whole thing, this is a code and so on, and that's your argument for saying common law just doesn't get in at all.
Yes, I mean, I'm perfectly happy with that formulation. We've formulated the argument in various ways as the argument has gone along. The Secretary of State, in the very early days, said Auckland Harbour, actually,
yes,
to which we said that can't be right because the money is paid out of the consolidated fund by express authorisation, namely the award, or the statutory scheme, coupled with the award. There's no room for Auckland Harbour. He then said money paid by way of under a mistake of law or a mistake of fact, to which we say, one, the code read as a whole doesn't naturally give rise to such a remedy. That's your lordship's point. And secondly, in any event, it's actually quite difficult to see where the mistake is, at least until 1998, because the Secretary of State making the payment is doing so under a statutory duty created by the decision-making of somebody else. But the two roll together to create a comprehensive code in which the common law power of recovery cannot readily or easily or consistently be found.
You say there's no room for Auckland Harbour where it's been paid out on the basis of a mistake, is that right?
Yes, there's no room for Auckland Harbour on the facts of this statutory scheme, where the scheme envisages an award made by a decision maker. That award is declared to be final. The award must be satisfied by the person obliged to make the payments, namely the Secretary of State. That is parliamentary authorisation for the payment out of the consolidated fund at the moment that the payment is made. There's no question about ultra vires payment, as there was in Auckland Harbour, because the payment is precisely what the Secretary of State is obliged by the machinery to do. And the Secretary of State, having initially, I think the explanation of part of this litigation, the Secretary of State initially thought there was an Auckland Harbour principle that could be paid in aid. He changed his mind very, very early on in relation to that, and instead said it's a mistake of fact or law leading to the original mistaken award. But that leads to all the difficulties that arise from the fact that at least until 1998 the two decision makers were separate. And there were difficulties even after 1998 because the Secretary of State is at the moment of payment obliged to pay pursuant to the award he's made until he supersedes it or revises it, in which case the obligation to pay falls away. And one of the difficulties which no one's explored is precisely how limitation, for example, works in those circumstances. So limitation is a cause of action arise at the revision or supersession. We think the answer, if there is a cause of action, must be yes. Does that mean limitation runs 6 years from the actual revision rather than the original mistake? We would think the answer was yes, but all of this is a very, very unhappy reading of a code. And that's our fundamental point. My Lord, those short submissions are against the background of the points that we've made in the printed case. Your Lordship has all of these, but can I just ask your Lordships to look at paragraphs 9 to 13 of the printed case, paragraphs pages 4 through to 6. Paragraph 9 sets out the legislative history. I don't think I need go through that. I think that a friend and I are one on it now, as I understand it. And it's quite right that Section 71 in its present form goes back to Section 53 of the 86 Act. And before that, there were two parallel regimes, Section 119 on the one hand and Section 20 on the other. Paragraph 10 makes the point I've just been making about the division between decision makers and the person responsible for payment. Can I just pick up, because it may not be so familiar to your Lordships, the second part of paragraph 10 makes the point that there was a division in the supplementary benefits decision-making scheme going right back to 1966, which is the inception of the Supplementary Benefits Act. Before that one is dealing in terms of national assistance. Early part of the Supplementary Benefits Scheme, the decision maker was the Supplementary Benefits Commission. That was replaced in 1976 by statutory officers, very similar to adjudication officers, who are supplementary benefit officers. And accordingly, we make the submission at the end of paragraph 10 that for the whole history until 1998 of Section 119, decision making for all types of benefits, created a situation in which the various recovery provisions form part of a system in which the payment of benefit was made by the Secretary of State in order to discharge a statutory duty which arose because of the decision on the award by a separate body. Paragraph 11 makes the point that no one's ever issued proceedings in pursuance of a alleged restitutionary claim, either in connection with the letters that have been written in the fairly recent past, or ever, as far as we know. And then paragraph 13 makes the point that Section 71.5, in its original form, was in very similar terms to Section 71.5a. And we've picked up the point that about the split in decision-making later in the printed case, in paragraph 16b on page 9. And that maintains a submission halfway down that paragraph, that under the old regime until 1992, until 1998, the Secretary of State paid the benefit pursuant to his statutory duty, and therefore there could be no questions he made a mistake of fact or law in making the payment, not responsible for making decisions on either the facts or the law. And then in paragraph 33, the Lordship has seen, Secretary of State attempts to produce two arguments for saying that despite that fact there might have been a restitutionary claim. One is the mistake is the Secretary of State paying on the award, believing it to be good, and not proceeding immediately to revision of the award. That, we submit, is highly artificial, but it faces also the problem that under the scheme until 1998, adjudication officers were the very people who revised the award. So the Secretary of State simply isn't involved in fact-finding or decisions on points of law under the statutory scheme until 1998. And it's that fundamental thing, feature, which makes it quite difficult to see that there is a common law ability to recover for mistake of fact or law, at the very least. So against that short introduction, can we go to the statutory scheme? We've seen all these provisions. I won't read them, but can I just take them through and highlight their importance in
Sorry, can I just ask you, I've got a question mark alongside paragraph 18 at D.
Yep.
The simple correlation between the circumstances in which the award will be altered and the circumstances in which recovery will be permitted. I mean, Mr. Reid is right, isn't he, for what it's worth, in the point that there is explicit provision for revision, retrospective revision of an award which was wrongly, erroneously in favour of the claimant, although by administrative error, and yet, on your case, no basis to recover that amount which you consider expectedly to have been overpaid. I mean, where's the simple correlation?
So, where are we?
We're at page 11D, paragraph 18 in the middle. And look at your printed case.
Yeah. Well, paragraph 8, yeah, I've got it. Well, what we're saying, it may not be very elegantly put, is that you are within section 71 in each and every case where there is a revision of the award, and you then recover where there's been misrepresentation or non-disclosure. Is that not, if the sentence that says that a simple correlation is wrong, is not getting it right, that is certainly what I say.
There isn't correlation.
No.
No, there isn't correlation.
There's no simple
in terms
correlation.
of end result, there isn't correlation. But in each and every case where an award might be recovered, and in each and every case where an award can't be recovered, you're within section 71 because of 71(5)(a). That's my case. I think I would rather agree that on reflection paragraph 18 expresses that thought wrongly, as I can put it like that. I'll come to the revision and supersession provisions in a moment, and it's certainly part of my case that the scheme deliberately provides for a downwards revision of an award in some circumstances where the scheme doesn't provide for recovery because the provisions of section 71(1) aren't met. But they all fall within 71(5)(a). So, going to the statutory scheme, tab 27 we've seen section 8. I needn't read any part of it. can I just highlight the one thing that may not be obvious is that although there's a relatively short list of benefits in 8 subsection 3, in fact the section extends to a very wide range of benefits because of 8.3a, benefit under parts 2 to 5 of the Contribution and Benefits Act, which is pretty well every non-means tested and means tested benefit. The ones that are separately listed are because, I think, almost all because there's separate legislative provision for them. They possibly fall outside 2 to 5. But benefits such as disablement, living allowance, ordinary retirement pension and so on, the commonplace benefits that we're familiar with, not least because of the current debates, are all under parts 2 to 5 of the Contribution and Benefits Act. Now, then we have in section 9 the revision provisions. It is worth picking up so that one understands the scheme, the contrast in 9.1a and b between the ability of the Secretary of State to revise within the prescribed period or in prescribed cases or circumstances, and either on an application made for the purpose or on his own initiative. And then there are provisions as to what date the revision takes effect. That's 9.3 and 9.4. And I don't think I need read the rest of it. If your lordships then go to the to tab 29, we are in the Social Security and Child Support Decision and Appeals Regulations 1999, and in particular its Regulation 3 that deals with revision. And the Lordship will see we didn't really look at 3.1, but it's quite important for understanding the basic structure. It provides, subject to the following provisions of this regulation, any decision of the Secretary of State under Section 8 or 10 may be revised by him if he or they commence action leading to revision within 1 month of the date of notification of the original decision, or an application for a revision is received by the Secretary of State or an officer of the board at the appropriate office, and then the first one is is within 1 month of the date of notification of the original decision. And then your lordships have seen regulation 9.5. Sorry, 3.5.
Oh,
sorry,
3.5.
it's entirely my fault. It's section 9 of regulation 3.
Yeah.
It's 3.5. Now, if I can just give your lordships our kind of thumbnail sketch of how we understand revision to work. Claimant can apply for revision within 1 month of the decision in question, and that's 3.1b1, and there are various variants on that in the remaining provisions of 3.1b.
Well, is it in 3.1a? Are these the
I've been puzzling about that. Yeah. I think it must be a situation where there's more than one Secretary of State. Because I don't know about Mr. E will inform you, but I've been puzzling about that.
But I mean, do I understand from what you're saying that a recipient of a benefit can apply for a revision?
Yes, exactly. I mean, the practical working of the scheme, on my understanding, what I'm being told from behind, is that the recipient of the benefit can apply within the prescribed period for a revision of the benefit. If that takes place, then the benefit is backdated in accordance with the terms of Section 9 itself to the date of the original decision. So that will be, by and large, a claimant-friendly revision that goes back to the date of the decision. The Secretary of State can revise on his own initiative, as we've seen from the terms of Section 6, Section 9, at any time, and he can revise at any time on the grounds set out in 3.5a, decision arose from an official error, and on the various categories in 5b, except in a case to which subparagraph C or D applies, where the decision was made in ignorance of or was based upon a mistake as to some material fact, and so on. So, the scheme works as follows. Secretary of State can revise on his own initiative at any time because of official error. That decision will take effect from the date of the original decision if he decides to revise. He is not obliged to revise, it's a discretion. And what certainly does happen is that claimants will write to the Secretary of State saying, you've added up my benefit wrong, that's an official error, I want you to revise pursuant to regulations 3.5a, back to the date. If the Secretary of State agrees to do that, then he comes under the statutory duty to pay the benefit, the extra benefit, which was originally undercalculated. If he doesn't agree to do that, because he says there is no official error, or I don't, for whatever reason, want to revise, the only remedy is judicial review. There's no right of appeal against a decision not to revise under 3.5a. If he decides to revise, let's just keep it with B to keep it simple, on the basis that the decision was made in ignorance of or was based upon a mistake as to some material fact, and as a result the decision was more advantageous to the claimant than it would otherwise have been, then he can revise, and once again that goes back to the date of the original decision. But on our reading of the scheme, before any recovery, one then has to ask the additional question, which Section 71.1 requires the Secretary of State to answer before he can recover. In other words, you've discharged the threshold condition in 71.5a. There is a revision that goes back to the date of the decision. Next question, does 71 actually give the Secretary of State a remedy? Answer, yes, if but only if the ignorance or mistake as to material fact arose because of a misrepresentation or failure to disclose. And we know from Hinchy that the failure to disclose must be in breach of some obligation imposed by the regulations. So that's the revision shed scheme. We say nothing in that supports any reading of the statutory scheme to suggest that a common law power can arise outside it. And I think this may be what I meant in paragraph 18, or that the regulations correlate. Forget that. If it's wrong, if it's wrong, it's wrong. But I think I am entitled to say that you can see the way in which 3.5b fits together with Section 71. You get the power to revise where there's an ignorance of a material fact or a mistake. Can you recover? Yes, if, but only if that ignorance or mistake arose because of the claimant's fault in a Section 71.1 sense. Your Lordship don't have the equivalent provisions for supersession. Your Lordship, to get hold of the whole picture, ought to have regulations 6 and 7 of the provisions. It's not just 6, it's 7, because 7 tells you the temporal effect of supersession. The learned friend is quite right that supersession is concerned with a change of circumstance since the original award was made. And the scheme, as I understand it, mirrors that relating to revision. That is, a claimant can apply for supersession if there has been a change of circumstance. Obviously, he will do that where the change of circumstance potentially leads to greater entitlement. If the Secretary of State does supersede, he will come under an obligation to pay backdated benefit to either the date of the request for supersession or the date of the change of circumstances if that actually came later. In other words, you can apply to get a supersession in advance of a change of circumstance you can see on the horizon. So the claimant has an ability to apply for supersession, benefit is backdated for a maximum of 1 month on those circumstances. If there's been a change of circumstance adverse to the claimant, for example, he's started work and therefore is disqualified from benefit, the Secretary of State can, of his own initiative, supersede. And there are a set of provisions that are very close to those for rescission, that the superseded decision will take effect from the moment of the change of circumstances, but the Secretary of State, we say, on the consistent with the whole statutory scheme, can only actually recover if he meets the conditions in section 71(1). So the two schemes, revision and supersession, walk together in that way. And I hope I've got that right. I've had some terrible times in the past dealing with supersession in particular. So going on with the statutory code, we've now got to the making of an award. Section 17 of the 1998 Act is the finality provision. And that is at tab 27. Section 17, I don't think anything turns on the terms of it. Section 17 is to be found at page 19 of tab 27. A final award having been made, the Secretary of State is obliged to pay in accordance with the terms of the award. That is Regulation 20 of the 1987 regulations, which are to be found at tab 28. Lordship will see that Regulation 20 says benefit shall be paid in accordance with an award as soon as reasonably practical after the award has been made. It's pricing stuff. And Regulation 17, 1 page earlier, is the provision that provides that normally awards will be indefinite. A series of other provisions in relation to particular benefits and so on. So, against that statutory scheme, go back to section 71, tab 25. As I say, in our respectful submission, the logical starting place is 71.5a, and we have a decision which has been reversed or varied on appeal. I didn't take your lordships to section 12, but your lordships will understand that there is a right of appeal in relation to section 8 awards, or has been revised under section 9 or superseded under section 10. Now, in all these cases, that revision or supersession has taken place, whether or not it's in the claimant's favour or against the claimant. And one then has section 71.1, and we submit the natural reading of section 71.1 with 5a is that it does form a comprehensive code. I should have taken your lordships to section 12 of the 1998 Act, tab 27.
I think we were showing it.
Yeah, I just want to make good one deficiency in the documentation. The primary right of appeal is conferred by section 12, again, where a decision has been made on a claim for an award of benefit. But then your lordships will pick up that 12.1b indicates that other decisions listed in Schedule 3 are appealable, and paragraph 5 of Schedule 3 lists Section 71 decisions. So the exact route for saying a Section 71 decision is appealable is 12.1b read together with paragraph 5 of Schedule 3.
Sorry, have we got Schedule 3?
No, that's why I'm telling you now, and it ought to go in the clip. All it says, I'll just read it to you, Lordship. A decision whether payment is, paragraph 5 specifies a decision whether payment is recoverable under section 71 or 71A of the Administration Act. That's all it says. But it just completes the... But it enables me to make a submission which is blindingly obvious and made already, that the code contains a right of appeal in respect to section 71 decisions. If my learned friend is right, then the Secretary of State can indeed litigate all the way to the upper tribunal or the Court of Appeal or the House of Lords or whatever the issue of whether or not the claimant has misrepresented or failure to disclose a fact falling within section 71.1. When the Secretary of State loses that issue, he can immediately commence common law proceedings on the basis of his alleged restitutionary claim, assuming that he doesn't meet a change of position defence. And the Secretary of State simply accepts that. We say that's a fundamentally unlikely reading of the scheme. Well, that's the scheme as it presently stands. Before the 1998 amendments, the 1992 Act contained Section 71 in the form in which it was originally enacted and in the context of the earlier adjudication system. Your Lordships have it at tab 26. We have we've included within the authorities bundle all the provisions that are relevant to administration at the time of enactment of the 1992 Act, and it does form, in our submission, an extensive and comprehensive adjudication system. Just to highlight the main provisions, Section 1 provides for entitlement to right being dependent on a claim. And then sections 21 to 25 are the heart of the adjudication system as it originally stood, page 14 through to 19. My friend showed your lordship section 20.
Section what?
20, page 14. Secretary of State receives the claim that the claimant has made to comply with the requirement of section 1. It then goes to the adjudication officer because it has to be submitted forthwith to the adjudication officer, see section 20, subsection 1. That adjudication system applies to exactly the same range of benefits as section 71 applies to, see section 20, subsection 6. The adjudication officer decides the claim, see section 21. There are then rights of appeal conferred in sections 22, 23 and 24, right up to the Court of Appeal. And then importantly, given one of the Secretary of State's submissions, section 25 provides for review and your Lordship will see that 25.1 provides that subject to the following provisions of this section, any decision under this Act, if an adjudication officer and so on, may be reviewed at any time by an adjudication officer or on a reference by an adjudication officer by a Social Security Appeal Tribunal if, and then A, the officer or tribunal is satisfied the decision was given in ignorance of or was based on a mistake as to some material fact, and then relevant change of circumstances is the other main category of review. There's a separate provision in 25.2 for error of law. And I'm not sure who it helps or hinders, but at the time of this enactment, it is a consolidating statute anyway, Kleinwort-Benson hadn't been decided. Mistake of law was not a recognised basis, fully recognised basis for a restitutionary claim. Certainly wasn't in 1975, because this consolidates essentially the adjudication provisions of the 75 Act. And then if your Lordship go on, yes. So if one puts a finger in section 25, as it were, and then in section 71 as originally enacted, which is some way further on, page 48, the provisions of section 71.5 as it then stood correlate with the revision provisions of section 25.1. And so it's a precondition. You get into, if you're the Secretary of State, you get into section 71 if there's been a revision or variance on an appeal or revision on a review, and that you can then recover if there has been a mistake of fact. Sorry, if the claimant is responsible for the mistake of fact or error of law.
Mr. Drabble, I'm not sure I've quite grasped what your point about subsection 5A or subsection 5 exactly is. You say, you say it's a starting point and so on. So I'm not quite sure I've grasped.
Well, as a statutory scheme presently, the point is this: in Monroe, in the tax case, and I may not need to fit exactly within the ratio of Monroe, that I accept, but on the basis that one is looking to see whether my submissions correlate with the statutory provision as analysed in Monroe, then my point is that if one looks at the width of section 71.5a, any decision which corrects an award is within the scope of the section. And so that you're within the scope of section 71 if there's been a revision or supersession in accordance with 5A. It's only a limited subset of those revisions or supersessions which give rise to the right of review, C71(1).
My difficulty just at the moment is, I mean, supposing you were wrong about saying that that 71 covered the whole field, then 5A wouldn't help you, would it?
No.
Because 5A is simply concerned with the situations in which you can get where this 71 applies, isn't that right?
Yes.
So it all comes back to the same thing, doesn't it?
Well,
I mean, if Mr. Eady were right, and by making it retrospective and under revision retrospect gave rise to a common law right, then 5A wouldn't help, would it? Wouldn't help you.
No. But the reason I'm saying this, and I may not need it, that I completely accept. But I'm going to go to this. Was going to go to this later. Let me go to it straight away because it's the passage that I have in mind in making this submission. If your Lordship will go to the judgment of Lord Justice Arden in Munro, tab 9, i.e. volume 2, tab 9.
Yes.
There's a passage which starts at paragraph 22 on page 86 of the judgment. Where Lady Justice Arden says, in my judgment, the authorities give clear guidance that if Parliament creates a right which is inconsistent with the right given by the common law, the latter is displaced. By inconsistent, I mean that the statutory remedy has some restriction in it which reflects some policy rule of the statute, which is a cardinal feature of the statute. In those circumstances, the likely implication of the statute in the absence of contrary provision is that the statutory remedy is an exclusive one. Now, pausing there, we do say the restriction on recovery, which on the case of section 71 is a restriction to cases in which there has been a misrepresentation or a failure to disclose, is a policy rule of the statute, which is a cardinal feature of the statute, to use her language. And just as in section 119, it would have been a cardinal feature of the statute that the claimant would have a defence if he proved he'd exercised due care and diligence. But going on, paragraph 23 says, undoubtedly Mr. Munro paid money under a mistake of law, and that remedy at common law in general exists in that situation. Such a right can, however, be excluded by express words or necessary implication. In this case, the implication arises because Parliament has created a specific remedy with a limitation to exclude payments made under generally accepted practice. That limitation would be defeated if the court permitted an action to be brought at common law. Principle applies even though the statute is a taxing statute, which must be interpreted so as not to impose burdens on the taxpayer unfairly. That was the obvious purpose of section 2A. It would make a nonsense of that purpose if it were possible to bring an action for common law for the recovery of money in circumstances where section 33 applies. And then this is the important paragraph. It is not correct to say, as Mr. Sherry submitted, that Mr. Munro's claim is outside section 33 altogether. It is within subsection 1, and the statutory commissioners have a statutory obligation, the commissioners have a statutory obligation to consider it. It is not open to the court to rewrite the structure of section 33 and treat it as not covering his case. Mr. Sherry emphasised the words under this section in subsection 2A. In my judgment, those words are against the claimant. They are indeed consistent with the intention by Parliament that section 33 should be an exclusive regime. They are not effective to displace the inconsistency to which the rest of section 2A gives rise. So, the thought, which I repeat, I do not need, it's not essential to my case, is that just as it was wrong for Mr. Sherry to submit that section 33 only applied where the defence to repayment was available to the commissioners, i.e. the payment had been made in accordance with a settled practice. So it's a mistake for Mr. Eady to say that Section 71 only applies, or only within the scope of Section 71, where the claimant doesn't have a defence to the claim for repayment because there has been a misrepresentation or failure to disclose. Just the one way of looking at it. You look at the scope of the section and then see whether the section applies across the whole range to a wide range of matters falling within it, a specific limitation on the recovery obligation. Put it like that, we do fall within it. That's the point. Now, I may not need it, and it may be overcomplicating it to say I do, but it was held against me at first instance, so I felt I had to deal with it. And we make the submissions on that, on the argument put like that. In paragraphs 21 through to 26 of our printed case.
Take this case of mistake of law by the Secretary of State. Nothing to do with the benefit claimant. How does what Lady Justice Arden says there apply?
Well, the mistake of law will have led to a revision or a supersession or a reversal on appeal, so that the precondition of 71(5) is met. You then, if you're the Secretary of State, come up against the limitation on the power to recover, namely there's been no misrepresentation or failure to disclose.
That only applies. I mean, that just takes you back to the idea that Section 71 fills the field.
Yes.
Because if it doesn't, then you're not caught by the by 5A.
I suspect we're using fill the field in two ways. The two ways are, is every potential Social Security decision altering an award within Section 71? Answer, yes. See the width of the terms of Section 71(5)(a). Does that help in the argument about whether it fills the field in the second sense, i.e. is an exclusive remedy? I think we may be thinking about the concept of filling the field in two different ways.
I think it's important to define what the field is.
Yes.
Once you've got the field clear in your mind, then the answer you say is simple.
Yes. Yes. I mean, the field, the whole history of the tax cases is the field is any overpayment of tax made pursuant to an assessment. Once you had that, then the overpayment was only recoverable by the taxpayer if the conditions of Section 33 were met, i.e. there hadn't been, if payment hadn't been made in accordance with a settled practice. I don't know whether there were other conditions, but that was the one that was in play in Monroe. The other tax cases are explicable on the basis of DMG, for example, that there was no assessment, so you just weren't within the field, if you define it like that. Now, that analysis is simply not open to the Secretary of State on the present case, because each and every variation of an award is caught within Section 71(5)(a). I mean, it's made under a decision described in 71(5)(a). So in that sense, it covers the whole field. The Rogers may prefer, if you put it on the basis that this is self-evidently a comprehensive statutory code. I mean, of course, I'm entirely happy with that.
You say the field is the award as finally whatever it is, revised, superseded, appealed, whatever else.
Yes.
And then 71(1) tells you when the exclusive circumstances in which actually in those circumstances the Secretary of State can get anything out of it.
Exactly right. And we do in fact say that on that basis the tax cases, rather than presenting any sort of obstacle to us, positively assist. And Lord Justice Lloyd didn't feel able to go down precisely that route, but made the observations that your Lordship has seen he made. But I don't disguise the fact that it may have been a difficult submission to understand. The submission I'm now making was the one that I made in the Court of Appeal, that the field is entirely covered by 71(5)(a).
This is not the case. I mean, trying just to understand. Supposing that Parliament had, I mean, Lady Justice Arden's thing, I follow. If it were, for example, common law, mistake of law, right, but Parliament has provided that you will have a right to recovery in the case of mistake of law if it occurred on a certain date, or if there was a particular quality to that mistake of law. Then in that situation, you would say, well, Parliament has done something which is inconsistent with that right, the common law right to recover from mistaken law. What I'm not quite clear about is why one says that if there is a right of recovery, a common law from mistaken law, this section, unless it just completely fills the thing, this section actually does provide anything in relation to mistaken law, right of recovery from mistaken law.
Well, I say it does, because the mistake of law will be a ground for variation, revision, or supersession. Has there been a variation, revision, or supersession? Answer: yes.
Yeah.
Does Parliament prescribe a remedy for a limited set of revisions, variations, or supersessions? Answer: yes. Those falling within 71(1).
But it doesn't seem to me to say anything at all, 71(1), say anything at all about the case of a pure error of law by the Secretary of State.
Well, it does by not.
By not, you just,
Yes,
that's
exactly.
what you've got.
Well, that is absolutely my point. It's what the learned friend submission is the other way around. He's trying to haul himself up by his bootstraps with all respect, because he's saying the only subject matter of section 71(1) is where there has been a misrepresentation or failure to disclose. That is Mr. Sherry's mistake, identified by Lord Justice Arden in paragraphs 24 and 25, he said. Anyway, that's the way in which I deal with tax cases. There are other issues which are to the effect that in any event it's extremely difficult for my learned friend to spell out what his restitutionary remedy is. If he is going to say, I can recover for mistake of law, see Kleinworth Benson, the answer to that, quite apart from the matters we've already been canvassing, is that the error of law is made within the award, earlier times in the chronology by an adjudication officer, post-1998 by the Secretary of State in an award declared final. What causes the payment, pursuant to the error of law, answer the Secretary of State's statutory duty to pay, pursuant to a final award. And it's not at all clear, in fact we positively submit, that there would in any event be no restitutionary remedy in those circumstances. Section 71 gets out of all of that by telling you that you can recover, telling the Secretary of State that you can recover in some cases but not in others. But on the face of it, the operative cause of the overpayment is not the original error of law which is in the enshrined in the award, but the Secretary of State's statutory duty to pay pursuant to Regulation 20 that we've already seen. My learned friend, I think, says, well, a common law right of recovery springs into life when the revision is made, which leads to all his problems with limitation periods and so on. It just looks hopelessly, we respectfully say, a bit artificial. Those are, I think, the shape of our submissions. Your Lordships ought to be aware, it should have been in the bundle, that there is one decision in the Court of Appeal which touches on this issue. It's not in the bundle of authorities. Can I ask for it to be handed up? It's a case called Steele. This is a bankruptcy case which was disposed of by a Court of Appeal consisting of Lord Justices May and Arden and Sir Martin Norse. Sir Martin Norse gave a judgment which found against Mr. Steele on two alternative bases. We needn't be concerned with the first one, but if your lordships look at page 2387, paragraph 16, the alternative argument that Mr. Stagg advanced in favour of Mr. Steele was that Mr. Steele was under a common law obligation to make repayment of the overpaid benefit by way of restitution as soon as he was paid it. Accordingly, Mr. Stagg submits that Mr. Steele was under an obligation incurred before the commencement of the bankruptcy within section 3821B of the 1986 Act. This submission was based on a misunderstanding of something which was said by myself, and Lord Justice Millett expressed himself in similar terms in Chief Adjudication Officer and Sheriff. That is in the bundle of authorities. The main question in that case is whether the claimant has the necessary mental capacity to make a claim. I said the claim and the misrepresentation being indivisible. If the claimant lacked the capacity to make a misrepresentation, she lacked the capacity to make the claim. In that event, benefit was paid to her in the mistaken belief that a claim that this had not been made had been made, and there being no power to pay without a claim, it was recoverable by the Secretary of State not under section 71(1), but on ordinary principles of restitution. Lord Justice Millett spoke to the same effect. It's clear that our observations were directed simply to the case where the benefit is paid without a claim having been made. Once a claim is made, the machinery of section 71 is invoked and there is no room for recovery at common law, whether by way of restitution or otherwise. Mr. Stagg's alternative submission must be rejected. So, after argument, there is Sir Martin Norse saying that section 71 is a comprehensive code. The position gets rather more complicated because Lady Justice Arden, in a rather classic way, says at paragraph 28, page 2390, in my judgment, it's not necessary on this appeal to express a view on the question whether section 71 supersedes any remedy at common law. Mr. Steele's liability under section 71 arose after the bankruptcy order was made against him. That liability cannot therefore be a bankruptcy debt which was released on his discharge from bankruptcy. In my judgment, that would be the position even if there were at the date of the bankruptcy order a separate liability at common law to repay benefits overpaid, and that liability constituted a provable debt, as to which I express no view, which was released on Mr. Steele's discharge or was displaced by the determination of the Secretary of State under section 71. So Sir Martin Norse decides the point. Lady Justice Arden says, unnecessary to decide it, and Lord Justice May says, I agree. It's like an exam question, you know? There was some debate in front of Mr. Michael Supperston as to whether Lord Justice May was agreeing with Lady Justice Arden's statement it wasn't necessary to decide the case, or, as your Lordship guess I submitted, agreeing with Sir Martin Norse's observation that it was completed. Your Lordship needn't determine any of that, but there is a Court of Appeal decision in which a view was expressed, and your Lordships ought to know that. That, I think, are the submissions I wish to make. Your Lordships hope I now understand the position as to Hinchy. Lord Justice Aldous did express a view in paragraph 10 of the decision about the relationship with the common law. There was no argument at all in front of the Court of Appeal about that. It simply wasn't necessary to engage with it. I think Mr. Howell did in his skeleton indicate the way the scheme worked. And similarly, there was no argument at all in the House of Lords about the way in which Section 71 related to the common law. So that point was simply not argued. Unless there's anything else on which I can help, those are our submissions.
Thank you, Mr. Travell. Mr. Turney? Yes, Mr. Ely.
My Lords, 71.5, the VEX 71.5. My learned friend's core submission is that 71.5A, as it now is, 5 as it was, is the key to this case. And he says that that is because it indicates that Parliament was intending to deal, and to deal exclusively in this section, with every circumstance, every case in which there could be revision. My submission in relation to that is that section 5, subsection 5 and 5A are there for a good reason, and the good reason does not indicate that this section was intending to cover the entirety of the field, in other words, all cases in which there had been revisions. Subsection 5A is advisedly down the scale in terms of number within section 71. That is because the structure of the section is to confer an entitlement in subsection 1, followed by a preclusion against recovery, brackets, which assumes the entitlement, in subsection 5A.
Just say that again.
Subsection 1 confers an entitlement. Where it is determined, etc., 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 the Secretary of State shall be entitled to recover. The language of 5 and 5A is different. It says, except where regulations otherwise provide, and an amount shall not be recoverable under subsection 1 unless. So that presupposes that the entitlement has already arisen under subsection 1. And what that indicates is that what 5A is there to do is to indicate that if you otherwise have an entitlement, brackets, the field, which is misrepresentation or non-disclosure, you can't exercise that entitlement. You can have no recovery, save in a certain specified circumstance. And that circumstance is where there has been a revision of the determination in pursuance of which the money that you're seeking was paid. And what that indicates is that it is, as it were, subsection 5A is a provision which exists after the entitlement has arisen, but precludes recovery in certain circumstances. And it indicates that you can't make a recovery, despite the entitlement that would otherwise have arisen, unless in relation to that particular payment, not all payments generally, but in relation to that particular payment, there's been a revision of the determination. And the reason that it does that is to bring in line these provisions with the finality provisions under section 17.
So when does the limitation period start?
Well, my Lord, when the entitlement would arise under 71.1.
And that is?
That is when there has been a payment triggered by misrepresentation or non-disclosure.
Where it is determined that there has been such an
Or determination, sorry, yeah.
Yes.
I'm being corrected from behind as well as in front. A double error.
Sorry, the point of determination of misrepresentation.
Yes, where it is determined.
Which is an appealable decision.
Which is an appealable decision. Under the provisions of Schedule 3, as you saw. What my learned friend says is you reverse the structure of this section. It covers everything, under subsection 5A, so including species of error which are simply not referred to at all under section 71.1. And then it purports to limit, through the provision of a special entitlement with all the special relief that goes with it, in a manner which provides a comprehensive and exclusive scheme. And we respectfully submit that subsection 5A can perfectly properly exist.
But the area of recoverability is surely defined by section 71.5A.
Well, there has to be a revision. You have to have concluded in the first place that the original determination was wrong.
Why should the area of recoverability not be identical to the field?
Well, my lord, I mean, we say because 71.1 is providing the special remedy. It's saying here is a particular and special entitlement in circumstances where there is misrepresentation. What you have to do, of course, in relation to that field, that category, is to bring the processes in line. You've got to revise first. But we say that to use section 5A, as it were, to drive it, and then imply from 5A that subsection 1 is providing the sole and exclusive remedy, is a difficult thing.
Well, if you start from the proposition that you must define the field, then there is a logic, is there not, in saying that the area of recoverability is the definition of the field, and what is section 71 subsection 1 is doing, despite its prominence in the, as you put it, the structure, it is merely giving voice to the remedy within the field.
Well, my lord, we, as you know, put it the other way around.
Yes.
We say that the field is properly to be determined in this particular context by the fact that Parliament has chosen to provide a special remedy with all the special features determined under subsection 1. And there is, even if you approach it in that way, we respectfully submit, there is still purpose to 5A, because it then deals with and provides a requirement in relation to the particular species of case with which this section is dealing, namely those cases where there's been misrepresentation and or non-disclosure.
You're already saying, I think, that you have to read 71.1 when it says shall be entitled to recover as if it said subject to 5A.
Well, my lord, one would read it that way. You don't need to imply the words in there because...
No, but that's the effect of what you're saying.
Is it?
Yeah.
In what proceedings is the determination referred to in 71.1 going to take place? Because one would have thought that the issue of whether there's been misrepresentation, etc., is likely to arise in the proceedings for reversal, variation, or revision. That's the first thing that's going to happen, isn't it? There'll be... in practice?
I don't know whether in practice that would happen. One can quite see how it might arise in those proceedings, because it would probably form the basis on which it is then altered and revised. Well, it's difficult. Well, it depends which door you come through to get to the section. Do you come through the 5A door, or do you come through the 71.1 door?
Which gate?
Which gate? Exactly. Which gate into the field? Quite.
And the limitation period starts if it isn't a case of misrepresentation or non-disclosure, if it's domestic error, office error.
From the determination.
Which
From the determination that the award should be revised if it's official error.
From when? From when
the determination of revision is done. In the case of official error, because my law will recall that you can revise for official error.
There's a different starting date.
My lords, we say that 5 and 5A, as I say, exist to provide an additional precondition to recoverability in cases of misrep and non-disclosure, and they do so for good reason, to bring the the determination on both fronts, as it were, in line with Section 17 and finality.
But it's also a precondition you accept in the case of official error.
That there should be a determination.
No, that there should be a revision.
Yes.
But in the case of official error, the limitation period starts at the date of the revision, whereas if it's a misrepresentation, it's at an earlier date, the date when the Secretary of State decides there's been a misrepresentation.
Well, yes.
Subsection 2 tells us, is that right, where the determinations, who makes them?
Subsection 2 is dealing with the subsequent determination in relation to amounts. So you've got two types of determination. First is 71.1 and the second is 71.2, dealing with amounts.
Yes, but I mean, it tells, where any such determination, as is referred to in subsection 1,
Yes.
the person making that determination,
Yes.
and it tells you who these people may be, Secretary of State, First Tier Tribunal, Upper Tribunal Court, is that right?
Yes. My Lords, Mr. Drabble also submitted that this provision, this set of statutory provisions, is equivalent to the relevant provisions in Munro, and that we're operating under the same error, as it were, as Mr. Sherry was operating under in Munro. If you just take up Munro for a moment, if you would, please, so bundle 2, tab 9. And you can see, if you go to the very back of that report, you'll see the relevant terms of section 33. And it then becomes pretty obvious why the conclusion was reached as it was, in distinction to the DMG case, where a different result was reached. See in particular subsection 2A. That is a positive preclusion against granting relief in certain circumstances. So you have got the clarity in the express words that are required in that situation. You have got the direct inconsistency in that situation. And indeed, that was the critical feature of the case. If one goes, for example, to paragraph 12 of the judgment of Lady Justice Arden, where she quotes the Chancellor's conclusion at first instance, with which ultimately the Court of Appeal agreed, page 77, between the letters C and D, you'll see that what is said is it would be inconsistent with 33 to recognise a common law remedy, that's the restitutionary remedy, in precisely the circumstances postulated in subsection 1, but free of the limitation contained in section 2A. So the difficulty there was that if the common law restitutionary remedy had been allowed to run, it would in effect have afforded a remedy in circumstances where Parliament had expressly said, well, you can't have one. So it could have been used directly to circumvent the relevant statutory scheme. And we respectfully submit, therefore, that that is a clear case and a clear application of the principle for which we contended. Namely, that if you're going to exclude a common law right or remedy, you've got to do so on the basis of the clearest possible words. And it couldn't be clearer. If you've got a statute that says, thou shalt have no recovery in circumstances A, B, and C, and the effect of a common law remedy would be to give you a remedy in precisely those circumstances, there is plain and direct inconsistency. And we say that that simply is not the position, or anything like the position, in relation to section 71. And that ultimately all that section 71 is doing is to provide a special remedy for a particular set of circumstances in which the claimant has made a misrepresentation or a non-disclosure. It requires the statutory scheme to then be brought in line, as it were, so that section 17 is dealt with, that it is fundamentally there to provide a special form of relief and does not lead to the sort of necessary direct inconsistency of the kind that was found and was self-evidently there in Munro. And the only other point by way of reply is to note that ultimately my learned friend didn't have an answer to the regulation, the 1999 regulation, section or paragraph 3(5). And his case does involve the proposition that one could have, as it were, at least in certain circumstances, and they're likely to be usual circumstances in cases of official error, that the relevant legislative scheme provides for purposeless revision in circumstances where there is to be no recovery across a wide swathe of cases, i.e. those that are dealing with official error. Anything outside misrepresentation or non-disclosure, he says, is positively excluded by this scheme. And we say not merely does the section not lend itself in any shape or form to that, it isn't directly inconsistent with the continuing existence or the existence of parallel common law rights, but that it would in any event create serious incoherence in the legislative scheme. For that reason, my Lords, rather than taking up time now, I'm told by my learned junior that the Steele case, for all its confusion, was the subject of some submissions in the Court of Appeal. Perhaps if we can provide with the clip that we're going to provide to you anyway, the short paragraphs in that deal with our submissions in relation to Steele. In essence, it will come as no surprise to you to know that what we say about Steele is that, of course, Sir Martin North said what he said, but that there is at least a little confusion as to how great a degree of support there was for that position from the other members of the Court of Appeal in that case. My Lords, unless I can assist further,
there's just one question that's been puzzling me. Under section 71, the recovery is to be sought from the person who misrepresented the fact or failed to disclose it, not necessarily the recipient.
Yes.
Can you bring an action or make a claim against both that person and the recipient in common law at the same time, or one after the other if one is not satisfied, or if a claim against the person who made the misrepresentation is satisfied, presumably that expunges any common law claim?
That must be right.
Yes. But could you actually join them both on different bases? Has one any right to contribution from the other?
Well, the question there, I suspect, is whether or not the joinder of any one of those in a common law action would be positively inconsistent with the statutory scheme that we have in section 71. And on that basis, the only positive preclusion, the only direct inconsistency would be against proceeding for misrepresentation or non-disclosure against the individual concerned.
I mean, he might be denying it.
He might be
I didn't
denying
say
it.
that. It's your fault.
Well, in which case that would have to
Then
be
you want the common law claim.
quite. No, will you give me a moment?
Yeah.
Maybe there's a further and better answer to come. Mr. Henshaw reminds me that the claim in restitution would be likely in any event to be against the payee. That doesn't necessarily, I think, meet my Lord's point, which is you may have another cause of action in misrepresentation against someone else.
So why would it be against the payee under subsection 3?
Because the payee would be the person... Oh, no, this is the restitution.
Oh, I'm sorry, a restitution.
Because he would be the person unjustly
that's against
enriched.
the payee.
Yeah.
But I'm considering that the restitution claim against the payee
Plus
a subsection 3 claim against the misrepresenter, who's ex-hypothesized. This situation isn't actually the payee.
Yes, I suppose the answer to that is, in short, one could have that, but the sort of punchline injustice which may lurk behind my Lord's question may be met by the fact that if one pays, it would expunge so far as the other is concerned, and that it's not realistic to expect that you'd end up with the hideous prospect of a double recovery.
And there's a touching on this point, not obviously in relation to common law, but the possibility of the various different avenues of recovery is actually touched on in subsection 8. I don't know what the regulations are, or indeed what section 74 says, but where any amount is recoverable under subsection 1, all regulations, or under section 71, it may, without prejudice to any other method of recovery, be recovered by deduction from prescribed benefits.
Yes. Well, so one has potentially more than one route to recovery, and that is certainly contemplated by the section, but it may be that's one stage removed from the point that Lord Phillips was raising with me, which was about, in effect, about initial entitlement and concerns about that. Certainly, my Lord is right that the section does contemplate that, particularly if section 8 is read alongside section 10, to which attention has already been drawn, which provides another mechanism for recovery. But both of those assume, as it were, an initial entitlement. I don't know if that assists or meets the point that was troubling my Lord. Well, those are my submissions.
We're grateful to Council for their submissions and we'll reserve our judgment.